Lindsay, what is a power of attorney and why do we need one?
Sure. So a power of attorney, I should say first that it's one of the two documents that I refer to as a lifetime document. The reason I talk about it as a lifetime document is because it stays with you during your lifetime, but it dies when you die. And that's a really important thing for people to realize from the outset of this discussion, because the power of attorney, sometimes I get a call from a client or a potential client saying, my mom died last week, I've been paying her bills using her account, but it's okay because I'm a power of attorney. And at the outset, I just want to say that that's actually not how this document works. Rather, the power of attorney stays with you, like I said, during lifetime, and it is a document that allows someone else to step in your shoes to be the agent with regard to your financial and legal matters. So again, someone comes in, someone steps in your shoes and can sign contracts for you, can access your bank account for you, can do various things for you based on the actual document so that you don't have to do them for yourself, particularly if you can't do them for yourself. Now, you asked why you need one. Everyone needs one. So if you're above 18 and you're breathing, you need a power of attorney if you don't already have one. The same goes for a healthcare directive, but that's a discussion for another day. So, and that is regardless of what your personal situation is, whether you're married, single, old, young, any of those things, and also regardless of your financial situation, whether you have a whole bunch of money or whether you have more of a modest estate. Because without this document, no one is permitted to step in your shoes and act for you if you become unable to. So again, the power of attorney allows someone, you name someone as your agent. Sometimes that person's referred to as your attorney in fact. So those terms are interchangeable, to act for you with regard to your assets and also to make legal and financial decisions for you. So even if you're married, your spouse is not legally your agent just by virtue of marriage or intent, really. Although your spouse will be able to access joint assets, they will not be able to unilaterally access any separate assets, any assets you hold in your name alone, such as separate bank accounts, if any, and certainly not any retirement assets, because those can't be joint. Also, they won't be able to do things that you may want your agent to be able to do, such as update your estate plan and things like that. So one thing that comes as a surprise to most married people as well is that if you become incapacitated, your spouse, even if they are a joint owner on a bank account or on a real estate, even if your spouse is a joint owner on your real estate, they cannot unilaterally sell or mortgage your home. And that, again, comes as a big surprise for a lot of people. But if you think about it, if you've ever sold a home, both people on the deed need to sign the new deed, right? If you and your wife own a home and you sign over the deed to sell your house, both of you are going to sign that new deed. Well, if your wife is incapacitated, you don't just have the ability to sign for her because you're married to her. Rather, you need this document to allow you to sign as her agent. So that's very important.
So I'd like to stick with the incapacitation for a second. So what happens if you don't have a power of attorney and you become incapacitated?
Yeah, that's a really good question. So if you become incapacitated and you need someone to act for you, for example, to pay your bills, access your bank account for that purpose, or things like that, you will not be able to have someone else fulfill that role without that power of attorney. So your spouse, your child, your sibling, your parent, your friend, even the nursing home, if that's your situation, will instead have to go to the court and ask a judge to appoint them as guardian of your property. So I want to make one quick distinction here. There's a couple types of guardianships, or that's sometimes called a conservatorship in certain jurisdictions if it's for someone over the age of 18. But for our purposes, I'm just going to call it a guardianship. So when we're talking about your assets and your power of attorney here, we're talking about the type of guardianship, a guardianship of the property. That's completely separate than guardianship of the person. Guardianship of the person is who's going to control where you're living, who your doctors are, what surgeries you're going to have, that type of thing. Again, that's more of a discussion when we talk about healthcare directives. But here, someone's going to have to ask the court to legally appoint them as your agent, as guardian of your property. And they're going to have to file a petition, which probably is going to be prepared by an attorney. And Jason, when I say the word attorney, if you see dollar signs in your mind, I won't be insulted. You and I both know attorneys, we charge for our time, right? We have to. So the attorney is going to prepare the petition. Another attorney, which means more dollars, will be appointed for you as the alleged incapacitated person. And then the court will probably even send an investigator to come out and decide whether you are actually incapacitated or not, right? So is it mom really does need help with her finances, she can't handle this stuff on her own? Or is it greedy daughter is trying to become mom's agent because she wants access to all of her money, right? So the court would, and it makes sense, so the court would send out an investigator to determine that. And as you may have gathered by now, this is a very expensive as well as time-consuming process. And that's even if the whole family is in agreement. So the whole family agrees that the oldest sister should be mom's legal guardian. That's what we call an uncontested guardianship. So even with that, the family not fighting, it's a very expensive and time-consuming process. Now, if the family does not agree, it's going to be a contested guardianship, which is even more time-consuming and more difficult and more costly and emotionally straining and all of those things. And when talking about this, it's really important to remember that the person the court appoints as your guardian may not be the person you would have wanted, right? So say in that scenario I just mentioned, mom is the one who's incapacitated, oldest daughter thinks she should be the agent, all the other siblings just don't want to fight about it, right? They just know that she's gonna win one way or another, so they might as well just consent. But really, if mom had have done this document, she may have appointed her youngest son because he's the one that's the most responsible or that she trusts the most or what have you. So if it goes down this path, there's no guarantee that the court will appoint the person that you would have wanted to be appointed if you had have made that decision yourself. So to avoid all of this, what we do is we create the power of attorney while you're alive and well. And when I say well, I mean you have capacity, and you name the person you want to act for you, as well as the powers that you want him or her to have.
The types of powers of attorney, how many types are there?
There's several. There are several different types of powers of attorney. So the number or the appropriate one depends, or ones depend on where you live. So jurisdiction matters in this case, and I don't mean what county in Maryland, for example, or what county in California or what have you reside in. I mean what state. Whether you want your agent to have very broad powers, which would be a general power of attorney, or whether you want some limitations, which would be considered a limited power of attorney. Now, with regard to the general power of attorney, I will say that calling it general is aspirational. It is not possible for me to write a power of attorney that says, I authorize my agent to do everything I could do, you know, dated, signed, notarized, that's it. Instead, you need to list out all of the powers that you want your agent to be able to have. And it's really important to remember this because, for example, your agent under your power of attorney is only legally allowed to use your money for your benefit. And that's exactly what we want, right? We don't want to give someone the authority to decide how they should use our money. We just want to give them the authority to use our money for our benefit. But you need to remember, if anyone else is relying on you, that has to be specifically stated. So for example, if you help your mom pay her rent every month, and you want your agent to continue that, even if you're incapacitated, then you're going to have to specifically write that in your document. Otherwise, your agent won't have that authority. Also, if you want your agent to be able to make gifts or donate money consistent with your prior pattern of giving, things like that, those need to be specifically stated in the document in order for your agent to have that ability. Some other examples that you might want of powers that you might want your agent to have would be the power to change your estate plan. That's a big one. The power to update your beneficiary designations, the power to sell your real estate, the power to access your safe deposit box, and there's a whole lot more, but those are just a few examples. I know it's a lot, and a lot of times when I'm talking to clients about this and about those big powers like update your beneficiary designations and change your estate plan, they think, whoa, I don't want them to be able to do that. What I'm doing today is what I want. Or they might say, no, I never want to leave my house. I want to die in my home. I never want to go to assisted living. Well, we can plan as best as we can, but we all know we don't have that crystal ball, right? We don't know if someone is going to fall ill or for some reason have to move, right? That happens all the time. People need more assistance, they move to assisted living, things like that. And whether it's, you know, in the mind of the person drafting the document at that moment, or whether it's an illness that comes 50 years down the road, we just don't know. Same with updating your estate plan. You don't want to lock, generally speaking, you don't want to lock in your estate plan so that it can never be changed, because as we know, laws change, things change. I won't get into the discussion right now, but there recently was an IRS ruling, the Secure Act. You may or may not have heard of it. It's pretty much brand new, just a few months old, and that is making us reevaluate how retirement benefits are left to certain beneficiaries. So for example, that can impact someone's estate planning greatly. So if someone had documents and didn't allow, or didn't have documents, or didn't allow their agent to update their documents, then they're stuck, right? They're stuck with the old drafting, and it just is what it is. So we generally want our agent to have that flexibility if necessary. Oh, go ahead.
No, please go ahead.
I was just going to say, if you, on the other hand, want to limit your agent's authority, for example, to a specific event like a real estate closing or a specific time period, or even a specific asset, such as a certain piece of property or a certain business interest, then you would have to execute what's called a limited power of attorney, and that name makes sense for sure. Some states also have what's called a statutory power of attorney, and depending on the jurisdiction is whether you have it and whether it's a standalone document, or, for example, in Maryland, it is a separate document, right? So my Maryland clients will have 2 powers of attorney, my Virginia clients will have 1. So, so all of these concepts that I'm talking about today are true across the board, but the specifics are, you know, there are some state-specific laws, of course. So that's kind of the different types of powers of attorney in a nutshell.
Thank you, Lindsay. I'd like to just go back just for a second. You had mentioned the family disputes potentially, which I'm sure you know that happens more often than we care to know. So what do you do in that situation? Do you just, if you've got a family member in another state, do they get their own attorney and then you represent this person? So, I mean, what does that process look like?
It looks pretty bad. So if the family is disagreeing, now, if you're talking about that guardianship situation, right, where mom didn't have any documents and everyone's fighting over who should be guardian or whether she needs a guardianship, then yeah, what you said is essentially true. Everyone basically hires their own attorney and they fight it out in court, and it's a big old litigation, right? So that's a problem. Now, when you have these documents, I'm not saying people won't fight. People might still fight, but as long as you have legally binding documents, the litigation isn't going to go very far, right? There's basically a few reasons you can contest most estate planning documents, such as duress, undue influence, incapacity, things like that. So unless you can prove one of these very specific elements, it's saying mom always favored her or I should have been named, that's not enough. So that's a good question, though.
Yeah. So let's move forward, Lindsay. Who should you name as your agent?
Sure. That's a really important thing to consider when you're deciding to do a power of attorney. Who should you name? Now, if you're married, a logical first choice may hopefully be your spouse. For those people, it's who should I name as a backup? If you have one adult child that's responsible, that you trust, he or she may be the next logical choice. But issues sometimes come up when clients are not married or do not have adult children, have multiple adult children, or don't have much confidence in their adult children. So when helping those clients decide on who to name, whether in this capacity or really in any fiduciary role. So also this comes in when naming a PR, a personal representative, or an executor of your will, or a trustee of a trust. What we tell clients to look at, the two characteristics we think are most important are trust and common sense. When I say trust, a lot of people have a nice long list of family members they trust. When I say common sense, a lot of them, that list is cut in half. But remember, the agent doesn't need to have any special technical abilities, right? You absolutely need to trust them. You're putting a lot of faith in them. You're giving them access to your money and all sorts of stuff like that. So the trust goes hopefully without saying. But the common sense isn't, do they need to be a CPA and know how to physically file your tax return? Absolutely not. But they have to have the common sense to know, oh, it's March, I'm sending my tax stuff to my CPA. I better send mom's as well since she's incapacitated and I'm in charge of her finances. So remember, the agent can hire professionals as well to help him or her fulfill these roles. So sometimes I have people ask me, can't you just do it, or can I have a professional do it? The answer is, yeah, you could potentially name a professional for any of these roles, for trustee or for personal representative or anything like that, assuming your state is large enough. I'm dealing right now with a case where a big trust company was named as a co-trustee for a trust that really doesn't have much money right now. So they are declining to serve, and we have to go around searching for a substitute trust company because of the way this document was written by another attorney many, many years ago. And we're scrambling to find a small enough, a company that will take on a small enough trust. So with that being said, there is the possibility to name a professional, but I always tell clients that should really be the end of your analysis. That should be, you have nobody else to name. If you're thinking about naming a professional, remember, the person you name, whether that's a sibling, a child, an aunt, an uncle, a friend, a coworker you've known for 35 years, whoever, they can hire professionals, they can hire an attorney, they can hire a CPA to help with the difficult stuff. but you're not having an attorney or a CPA do the easy stuff like open your mail, right? That would be crazy for you to pay me to open all your junk mail and go through all that kind of stuff. Whereas your sister probably won't charge for that. And if she does, her rates are going to be a lot less than mine, right? So remember that. And then when discussing, you know, who to name if you have, for example, multiple children, there's a couple good things that we can put in, because remember, the power of attorney is a document that is malleable. We can put in things that the client wants, we can take out things the client doesn't want. And so one thing that we do is allow for checks and balances if it's appropriate. And what I mean by checks and balances is, let's say you have 3 children and you name the oldest as your agent because that's the one you trust, that's the one with common sense, that's the one that makes sense. So you name that oldest child as agent under your power of attorney. Well, maybe you don't want them to have the unilateral authority to do one of those big things I mentioned, like sell your home or change your estate plan, update your beneficiary designations. Maybe instead, if you're like most of my clients, you're more comfortable having that child do the day-to-day stuff on their own unilaterally. And then if they have to use one of those bigger powers, they have to have their siblings sign off on it. And a lot of people are much more comfortable knowing that if one of those big powers are used, you know, all their kids have to consent to it, rather than oldest sibling, oldest child just decides to change your estate plan. Another thing that we can do is transparency. So a lot of times people will become suspicious if they're not getting enough information. So say you name your oldest child and that child has a full-time job and has a family of their own and has a million things going on in their life, as well as taking care of your finances. So if their younger siblings are calling them every other day asking what's going on with the money, you know, all that kind of stuff, they might stop answering the phone, right? And then maybe that child buys a brand new expensive Mercedes, right? So the siblings are like, oh my goodness, he's stealing the money. Well, maybe he just got a raise, you know, it's something like that, totally acceptable, totally reasonable, not stealing mom and dad's money. Well, if we had transparency in there, meaning the other siblings are going to get duplicate bank statements, it can be as simple as that, or accountings, then they're going to see, you know, that Mercedes payment isn't coming out of mom's pocket. So everything's fine. So that kind of is another tool that we often use. Now, I will say that if you have other children that have a tendency to just make things a problem, then those tools might not be appropriate. Those might hinder your agent rather than help. So those things need to be discussed. So some people also ask me about naming multiple agents in that same scenario where they have the multiple kids. And, you know, technically, yes, you can name multiple agents. You can do that either jointly, which means if they don't agree on everything, nothing happens, it's a complete standstill, or joint and severally, meaning either one of them can act on their own, even if in direct conflict with the other. So that can become a waste of time as well. For example, you know, agent 1 calls the financial advisor on Monday, says sell Chevron by Exxon. Agent 2 calls on Tuesday, says sell Exxon by Chevron. And the advisor is going to do both, and it's just going to be a waste of time and money. So if considering all of that, you do want to name multiple agents, be sure to consider how the agents get along today, right? People usually aren't the best versions of themselves when they're under enormous amounts of stress. So they're probably not going to be on better behavior when mom or dad is incapacitated. Also consider what their work styles are. If one of your children gets everything done really early and the other one is constantly asking for forgiveness for late fees, it's probably not a good idea to put them down to work together. And then think about how they might work together, not just in the short term, but in the long term as well. Because remember, we don't know how long their agency is going to last, if at all, right? So we advise everyone, like I said, from the time you're 18 till the time you die to have a power of attorney. But some people have capacity up till the very end. Some people, this is an insurance policy. They don't need it. They have it, but they end up not needing it, and that's great. Other people may become incapacitated at an unusually young age from an accident or something else, and this document may stay with them for years and years. So when you're considering who to name, consider that as well, the long-term possibility.
Okay. So when does a power of attorney become effective?
So that actually needs to be defined in the document.
Okay.
So you do have a few choices with regard to effective date. So one is immediate, meaning as soon as you sign this document, your agent has authority. One thing I want to say that some people get caught up on is if you're in front of a bank teller and your agent's in front of the same teller right next to you and you're telling them to do different things, they're going to listen to you, right? But it definitely comes up where you want something different, or if it comes up, I should say, that you want something different and the teller doesn't know that, they're going to listen to your agent because you named that agent to act immediately. Another option is springing, which means upon your incapacity as defined in the document, your agent can take on this role and can begin to act. So typically it'll be determined by two doctors, but keep in mind that unavailability, like being overseas, is not the same as incapacity. So for some of those people that are going to be, transferred overseas for work or something like that, and business needs to occur while they're gone, they may need to think about executing either a different type of power of attorney, like a limited one. If their house needs to be sold while they're gone, they could do a limited one, or doing an immediate one, an immediate general power of attorney. And then a third option is immediate then springing. It's a combination of the first two I mentioned. So it's immediate upon signing for your first agent, such as your spouse, and then your backup agent will only have the power upon incapacity. So that's an option that a lot of my married clients do like, but it really depends on the situation. It depends on the individual. But whenever we're talking about this, one last thing, always keep in mind that you should not just name the first person. You should always have backups in any of these documents, in your will, in your trust, in your power of attorney, in your healthcare directive, because if that first person is gone before you, is incapacitated before you, is in the car with you at the same time, it's as if you didn't have one at all, essentially, if no one is named as a backup.
Well, that leads me, Lindsay, to my next question, and is how often should the power of attorney be reviewed?
Good question. So I always tell my clients that they should review their estate planning documents every 3 or so years on their own. Take a look, make sure everyone named in there is still the people you want, make sure it still makes sense to you. And then every 5 years or so, they should have a meeting with me. Right now we're doing all of these on Zoom or a similar platform, but have a meeting with me and sit down and discuss the documents, because you know what changes have happened in your life. We know what changes have happened in the law. And until we sit down together, we don't know the other side of it.